morning. Happy Saturday. My name is Meghan Maes, and this is Being Civil in Minnesota. This is a Facebook group where I come every Saturday at 10 to answer questions about legal resources or legal information. This is not intended to be legal advice, nor does this make me your lawyer. I like to come here because I think there's a lot of good resources out there. I think there's some misinformation, and so I want to make sure people are getting the best information they can. It's been a busy year for everybody, I'm sure. The way that the court system operates is the legislature enacts the rules and the courts interpret those rules, and as a lawyer, I have to use those rules to advocate for my clients and advise my clients. So I thought one way to kind of end 2024 is to look at some of the highlights for the rule changes that happened this last year. Don't know what's going to happen with rules moving forward, but I can at least tell you what they are right now. So if you know anybody that has questions about the process or about a situation, you can direct them to Being Civil in Minnesota, have them join the group, and then they can ask questions anonymously where I will answer them on Saturday. All right, so top 5. Number 5. One of the rules that was enacted was that the court may not use the gender of either party over the other party. So may not have a gender preference. Over the years, I've heard some myths that Minnesota is a mom state. This, I think, is intended to clarify or get away from that assumption. The best interests of the children are what is determined when a court looks at custody and parenting time, and that's going to take into consideration who's providing the care, who is making sure that the children are getting all their developmental milestones met, their medical stuff done. And that's not necessarily mom or dad, but if your case has a mom that is doing more of those or a dad that's doing more of those, regardless of which one it is, that's what this rule is saying. So if it's a mom doing it or a dad doing it or an auntie or a grandma or a tia, they will not look at necessarily the gender there. And that's under 518.17. Okay, rule 4. Judges are now looking at the mental health of children. Specifically, mental health was added to the rules. And they are going to look at the mental health impacts on children if you're asking the court to restrict someone's parenting time. This is something that I believe courts had the ability and were looking at prior to this getting added to 118.175, but it just makes it very clear that the children's mental health is going to be considered. Okay, number 3. I've talked about it before, but in Minnesota there is a presumption of at least 25% parenting time for each parent. The rule changed to add the words "at least." Again, I think that was kind of understood in the statute that each parent is presumed to have 25% parenting time. All right, that's 25 for each, if my math is working this morning. Then that means there's 50% left over, and that is kind of what the court is going to look at as far as what is the court going to do with that remaining 50%. The number 2 top rule that changed in 2024 is that if a parent is failing to comply with court-ordered parenting time or the schedule intentionally, meaning they are doing it on purpose, and it takes away a substantial amount of time or makes a substantial amount of time unavailable to the other parent who's supposed to have the kiddo, then a court is going to look at awarding compensatory parenting time, meaning compensating the parent who was wrongfully denied the parenting time. And then the court is going to order the other party to pay for the costs and attorney's fees if they are able. So if you're bringing an action for enforcing a court order or compensatory parenting time, if the other person has the ability to pay your costs and attorney's fees and you're denied a substantial amount of time, the court has the ability to have them pay. I bring that up because last week we talked about costs and attorney's fees. And a court may change legal and physical custody if circumstances warrant. All right, last one, number 1. This has to deal with specifically child safety. Lots of questions about, do I have to provide a car seat? What if the other parent isn't complying with child safety restraint best practices? Well, Minnesota changed some of the rules with regards to child restraint requirements, and those are in statute 169.685. The Minnesota Department of Safety does a great job explaining these new rules on their website, so I would suggest that you definitely go there for that information. So one thing that they did is they increased a booster seat from 8 to 9, which for anybody who has an 8-year-old, I'm sure that was a super fun conversation right after they got out of a booster seat. You now have to tell them they have to go back in it for another year, but it's for their safety. And then there's also a rule that says, if possible, the children under the age of 13 are supposed to be in the back, if possible. What does that mean? Don't know. But I would assume that if you have room in the back of the truck or the minivan or whatever you're driving, the kiddos should be back there, buckled, safe. Hope you enjoyed the top 5 rule changes of 2024. 2025 will be interesting. We'll definitely cover some of those. If you have questions for next Saturday, please ask them at Being Civil in Minnesota on Facebook. You can also message them to me anonymously if you have, if you want to keep your identity private. I totally respect that. Keep asking questions, keep showing up. I hope you guys have a great rest of your Saturday. We'll see you next week.